Okay, good afternoon. I'd like to call the September Board of Adjustment meeting to order. And let's do a roll call.
Randy Mason.
Fred Townsend, the council.
Walt Castle.
Jan Conacy.
And Barry Brandt. I'd like to ask Ann if meeting and public notices were properly posted.
The agenda for the Board of Adjustment regular meeting was posted in City Hall and on the city portal on September 16th. The agenda notice was sent out from the city portal on the same day. The agenda was amended and reposted in City Hall and on the city portal on September 22nd. The public notice for case number 0822-07 for the property located at 11.5 Henlopen Avenue was posted in City Hall and on the city portal on September 1st. Public notice was published in the Cape Gazette on September 6th and September 9th, Post Press on September 14th, and Delaware State News on September 8th and September 9th. Notification specific to this case was mailed out to property owner addresses within 200 feet of the subject property, and signage was posted on the property.
Okay, thank you. I'd like to see if all parties are present. Is Carol Nacy and Monte Meltzer here? If you'd like to have a seat up here, please. Thank you. Okay. And was there any correspondence sent in for this case?
There's no general correspondence,
Okay.
but I do have an email from John Shedleski of 11 Henlopen Avenue, specific to this case.
Okay, thank you. And I do understand there are no minutes to approve for August, correct? We'll skip over that, okay? And is there any old business we need to take care of? None? Okay, so let's move into our case. So we have one case this afternoon to attend to, and it involves a variance request. In this case, the applicant is seeking relief from the floor area ratio, the FAR requirements. Under Delaware law, an applicant for an area variance must prove that the requirements create an exceptional practical difficulty. In order to determine whether an exceptional practical difficulty exists, the board must weigh in the following four factors. Number one, the nature of the zone where the property lies. Number two, the character and use of the immediate vicinity. Number three, whether the removal of the restrictions on the applicant's property would seriously affect the neighboring properties and their uses. And finally, number four, whether the failure to remove the restriction would create an exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This standard is satisfied only when difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. And Mr. Townsend, you want to add some clarifications to that?
I will. Thank you, Mr. Brandt. As you were just told there and have heard before, and had been reminded by Mr. Capone in his position as chairman for this group, there are these four standards established by the Quick Check decision. Those standards apply equally to both bulk and both area variances and bulk variances, and to use variances. But we rarely ever get a use variance application, and if we do, we're going to stop and pay extra special attention to that. The first two criteria generally come into play in the context of use variances, where they would be more central to the decision-making than they are in area variance cases. So just as a reminder, criteria one, which must be applied in every case, whether it be use or area, is questioning whether granting the relief would allow for some type of use which is inconsistent with the zoning district. And I think in the case that we have coming up, you're going to be able to come to the conclusion that the uses in the area or uses in that district and the use being sought or the relief being sought by the applicants is not creating an inconsistent use with the zoning district. So it's not likely to be a very dispositive factor in your decision-making. Criteria 2 asks you to look at the character of the areas, or character of the area in which the relief is being sought. And once again, that factor is not likely to play a huge role in your decision-making. However, ideally, we would like for you to address in support or in opposition to the application those two factors. The third factor and the fourth factor are the ones that are typically applied in the case of area variances. And I'm making these comments both for the board, for any audience that we might have, and for the applicants. So this board is going to be restricted from considering evidence that doesn't relate to those four factors. We don't operate as a very formal legal courtroom might in the case of evidence, but we generally are not to consider factors other than these four. Okay, any questions about that from anyone? All right, thank you.
Thank you. Our case today is for the property located at 11.5 Henlopen Avenue. This property is located in an R-1 residential district. Everyone who chooses to speak today will be required to give their testimony under oath. I'm going to ask our attorney, Mr. Townsend, to administer those oaths. We do not have a court reporter present today, so if a transcript is ever required, the court reporter will have to work from our recordings of this meeting. So please keep your voices up, speak into the microphone, and no cross conversations during the hearing. And before we get started, is anyone, we have one person in the audience, are you going to speak today? Okay, thank you. Okay, that's easy. Okay. All right, so let's move into the case, and first we will ask our building inspector, Matt, to go over the report.
Thank you, Chair, and I think a congratulations is in order. Good afternoon. Before you today is case number 0822-07, the location being 11.5 Henlopen Avenue. Carol A. Nacy and Monty S. Meltzer, 11.5 Henlopen Avenue, Rehoboth Beach, Delaware, 19971. The applicants are seeking relief from 270.21 natural area, floor area ratio, and lot coverage. And as a related code section, I've included 270-4 definitions to help further give further information. The applicants Carol A. Nacy and Monty S. Meltzer, owners of 11.5 Henlopen, Rehoboth Beach, Delaware, 19971, are seeking a variance to section 270.21 natural area, floor area ratio, and lot coverage to allow the placement of a manufactured plastic pergola over an existing deck at the rear of the main structure. The property is located at 11.5 Henlopen Avenue, Rehoboth Beach, Delaware, 19971, and is situated in the R1 residential district. The property is listed in Sussex County records as tax map number 334-14.09-107.00. The parcel is rectangular in shape and consists of approximately 5,535 square feet. Some background information for you. The original structure was built in the early 50s and underwent a 2-year remodel as described in the support documentation provided by the applicants. The most recent building permit applied for is to repair and replace an existing deck and boardwalk. The pre-manufactured pergola is to be installed on the existing deck once repairs are completed. The submitted floor plans do not show an addition of approximately 85 square feet, approximately 7 foot by 12 foot to the rear of the property. Upon research into the property file, this addition was added by valid building permit in 2005. The submitted floor plans also do not show that the front porch is covered by a second floor balcony. A portion of that second floor balcony is covered by an accent roof. And if you look into the definitions and relate that to that, you would note that those areas are now counted as floor area ratio as well. The applicant is seeking relief from the following ordinances: 27021, natural area, floor area ratio, and lot coverage. B, floor area ratio. In the R1S district, the floor area ratio FAR for the resident structure combined with the accessory structures, if any, shall not exceed 0.5. In R1 and R2 districts, related to this one, the FAR for the residence structure combined with the accessory structures, if any, shall not exceed 0.6 for the first 5,000 square feet of gross lot area and 0.3 for any additional gross lot area, or for properties incorporating an accessory swimming pool, 0.5 for the first 5,000 square feet of gross lot area and 0.25 for any additional gross lot area. And then A, the first 250 square feet of an open front porch shall be excluded from the gross floor area, provided that such porch is on the street side of the building at the first floor level, roofed, one floor with no living space or deck above the porch, meets the definition of open porch in 270-4, and is not heated or air conditioning. Any square footage in excess of 250 square feet shall be included in the gross floor area. And that's where the calculations for the front porch come into play. Allowable floor area ratio for this particular lot, as submitted and approved by prior permanent applications, the site is approximately 5,535.50 square feet. You can see that taking 5,000 times 60% gives you 3,000. With the additional 535.5, 30% of that is 161, for a total allowable of 3,161 square feet. As submitted, the existing floor area ratio for this particular application, the main dwelling first floor is 1,950. The main dwelling second floor is 1,519. There is an accessory dwelling. The first floor of that is 256 square feet, and the accessory dwelling second floor is 256 square feet, for a total combined floor area ratio existing today of 3,981 square feet. Here's where I included the definitions to give you an actual idea of what is included. I don't think I'm going to bore you. It's all available by looking at 270-4 definitions. C is where you're going to find that, the whole list of breakouts of what we did here recently. The proposed placement of the pre-manufactured pergola adds to the floor area ratio as described in the definitions. The floor area ratio for this construction is well beyond the allowable requirements due to being constructed prior to the adoption of more restrictive ordinances. The proposed placement of the pergola on the existing deck would add 184 square feet of FAR for a total of 4,165 square feet of total FAR for the entire property. The conclusion, because the property was constructed to prior zoning ordinances, the applicant must secure approval from the Board of Adjustment to allow the placement of the pergola structure. Should the board vote in the affirmative, the applicant shall provide a building permit application to the Building and Licensing Department for review and approval.
Thank you. This time I'd like to ask Ms. Nacy or Mr. Meltzer.
Are there any, could we ask if there are any
You want to
questions?
go questions? Yes,
I have a question. for the
we
board.
do have questions, okay.
Okay, thank you. Matt, on the definitions, have those definitions changed in the last, I'm going to say 5 years or so?
Yes.
And what has changed in those definitions?
We further clarified, we did some work to further spell out and clarify what we were actually counting as floor area ratio.
And when did that occur?
I believe that was at the beginning of this year. We spelled it out for both residents and residential and commercial
In
properties.
January of 2022?
I believe.
And is that when you included covered porches, balconies, decks, and patios?
No, they've always been included.
That's when okay, so
Yes.
C has always been included.
It was, yes, it was just added to further clarify.
Okay, so if they've always been included, I have a question.
Certainly.
I walk all over town frequently. There are pergolas everywhere. There are 2 right outside of City Hall. They're on Prospect Street, the corner of Columbia and 2nd, on houses that I am quite sure they weren't counted in the gross floor area. I actually had no idea pergolas were counted. I wanted one on my second floor deck. But my husband likes to grow tomatoes out there, so we're not having one. So how did this happen? You know,
And I'm interested in hearing the answer, but one thing you can't be sure of is when those pergolas were constructed.
oh yeah, I am.
Oh, is that right?
Oh, yeah.
You've
I'm
done
I'm
some
not going back to-
investigation?
Oh, there's lots, I'm not going back to old houses, I'm going back to new houses, I've watched them under construction.
Mm-hmm.
The ones I'm pointing out are relatively, that's why I asked,
Okay,
it's never
all
been
right.
changed.
Okay.
No, they're less than 10 years old, most of them are less than 5 years old, the ones
Okay.
that I know about. I've seen some in Country Club that I know have been there a long time, they just look like they've been there a long time, but no, the ones I've seen are relatively new.
So did you answer
So
Jan's?
how did
Like-
that happen?
Certainly so. Passed down from my predecessor, the gentleman that I replaced. This has been consistent with the interpretations that have, that the offices and the department have relied upon,
From your predecessor?
including present employments as well.
Okay, so people were putting up pergolas with approval from the building department when the code says they can't. Is that right, what you're saying?
I don't think that's what he's saying.
Oh, well, that's why I wasn't sure
Right,
what he
yeah,
said.
it's not that we're saying you can't do pergolas, it's just that they count for floor area ratio. So we have to include them. What we've further defined and to bring clarity into the definitions is that anything that is above you is counted as a roof structure.
I understand that, but I asked a couple of contractors, and they told me they were not counted in the structure, because I couldn't figure out how these giant houses got built and then add a pergola on top of it, and that's because they weren't counted.
I would advise them to always reach out to building and licensing for clarity.
Well,
Well, I think the other thing we can probably add is that to the extent they weren't counted, I did just look at when the changes to floor area ratio occurred. It was in October of 2021, so a little bit earlier than January, October 2021. But they did take that opportunity, the commissioners took that opportunity to clarify what is counted as floor area, what is counted as floor area for purposes of floor area ratio, and it's now clear that if you are under a roof structure, it's counted. So regardless of what happened previously, this current code is clear.
and it's being consistently enforced now? I'm sorry, and it's consistently enforced now?
It is, yes.
Okay, thank you.
Jan, any additional for Matt?
No, I'm finished, thank you.
Walt, do you have any?
No.
I've got
Okay, so I have a few.
So also to Matt, is it your understanding that there's no conflict over the calculations that you've done regarding the allowable floor area ratio for this property? I mean, has the applicant indicated that they object to the calculations in your report?
I've received no objections. No.
Okay, thank you.
Randy, any questions?
Well, it has been my understanding that pergolas are counted. I've never quite understood why, because they're open. And so you count the entire space, not just the rafters that are overhead, because they're open in between.
That's
But
correct.
it is, right. Well, no matter what we end up finding, I think it would be very helpful if the city could clarify that in, some sort of future, just so people would know. Because a roof structure versus a pergola, to me, can be considered different things.
Correct, and that's why we did that further work in the definitions to further spell that out so that people weren't surprised by it.
And it spells out pergola specifically?
It does.
Oh,
Go ahead, Walt.
Mr. Janice, that was in October meeting?
Yeah.
Okay.
Matt,
If I may,
You need-
yeah,
you
it does
need
not
minute-
specifically call out pergolas, but it says any kind of covering over those different areas.
right.
Pergola's a cover, it's not natural, it's not open to above, it has to be a cover.
Certainly is a covering, okay.
Yeah.
I guess certainly do that.
Yeah, where the building official is focused in this one is 270-4C3, which says gross floor area in a single-family and two-family dwelling unit is deemed to include, number 3 says covered porches, balconies, decks, patios, and unimproved areas.
See, and it's just that I think can be different interpretations for a covering. with an open covering like that. So, I mean, clarification would be helpful going forward. But that said, I do have another question. I think one of the other issues has to do with the 6.5 feet height. Theoretically, if this pergola was under 6.5 feet, would we not be having this discussion?
It would not be a habitable space at that point.
Okay, so,
So they wouldn't technically allowed to be using that area for a habitable area.
oh, I see, because it's about habitable. Okay, that's,
So that would mean that it provides, I mean, it represents bulk, but it would not be counted because it's not habitable space. Wow, okay.
Correct.
Let's do Walt, let's go to Walt first.
Oh,
You want to go Jan? Okay.
Yeah, I just want, so if you have a canvas awning on your deck, right? I mean, my assumption is, at least when I was thinking about a pergola, was because it was too sunny up there. It's great for tomatoes, though. So could you put a canvas awning, attached to your house, that when it opened it up, it covered your deck and gave you shade, which I presume is what people want. Yes, thank you. Yeah, like a retractable awning. People have them in front of their houses, so I
Historically, we have not counted those as permanent structures. If you're going to put a permanent structure in, that's when we take a look at the FAR. But your examples of retractable awnings, sailcloth materials that are becoming really popular, as long as they can be, if they're in a temporary nature, we don't necessarily count those as
So
floor
you
area ratio.
attach it to the side of your house, and then you have it like an awning? Okay.
Correct.
All right, thank you.
Matt, just for clarification, where the deck is today, there is no structure over top of that right now, correct?
Correct.
Okay. And as far as the calculations, that deck, is it currently included in the FAR, or in your calculations on this application, not included in the FAR?
As it stands right now, the deck is not included in the floor area ratio calculation.
Thank you.
Only when you add the cover would it be added to that calculation.
Okay.
I just had another thing about natural area then, but the deck takes away from the natural area, so the property doesn't meet the criteria for natural area, correct? Am I reading those numbers right?
That's correct.
Okay, and the deck, if you took the deck away, would it meet the criteria?
I would probably say not,
Yeah, okay.
because it was built, again, the structure was built to a time
Right,
zoning
right.
codes were
Yeah,
completely different.
Exactly. Okay, I just wanted to make sure.
Okay. Any further questions for the inspector? All right, thank you, and thank you for bearing with us here.
It was actually fun, thank you.
Would you like to speak to your application?
Well, I mean,
First, we have to swear you in.
oh, yes.
So just a couple of ground rules. We are creating a record here, and there's at least the possibility that we'll need to make an account, a stenographer will need to make a written record of our proceedings. So we're only going to ask one of you to speak at a time.
Okay,
And it looks like, Ms. Meltzer, you're going to begin? Is that right?
that's right.
So I just need a name and an address from you, and then I'll administer the oath.
I'm Carol Nacy, 11.5 Henlopen Avenue, Rehoboth Beach, Delaware.
And do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but
I
the
do.
truth? Okay, you may proceed.
Thank you. So we used to grow tomatoes on our deck, and it is true. It's wonderful. The problem with our house is that the sun goes over the top and goes to the back, and so the sunlight is from anywhere from noon on. It's all sun in the back. The other problem is in the front. We've changed the character of Rehoboth Avenue, of Henlopen Avenue. We've now put bike paths in on both sides, and it's wonderful to see the bikers, but they're always talking, always moving, always calling to each other. We've also made Henlopen Avenue where the buses run when there's public festival going on, and so we have that as well. So sitting on the front porch these days is like sitting in a high-trafficked area like Rehoboth Avenue. And so our hope was to be able to and we did not realize that a pergola was, because of the reasons that you were talking about, because it's open, was something that would create a problem for the town. We deliberately structured it so that it cannot be used for anything other than a pergola, where if we get permission to do it, it's in plastic. It's not load-bearing. There is no way to enclose it. And as we understood, the issue of clarification is that the city had allowed porches to be built and not in the FAR, but people were putting jalousied windows in and making them enclosures and making them living space. We don't intend to do that. We would just like to be able to sit in the back on the high traffic times for our particular street and enjoy the sun streaks that come through the various boards that sit on top. So really what we're looking for is peace and quiet and enjoyment of our home. We've been here since '93. We've really enjoyed Rehoboth, and so much so that we will retire next year in September when my husband is 80 and I am 75, and we hope to enjoy it the rest of our time. Is there anything you wanted to say, Monty?
So first, any questions for Ms. Nacy? And I apologize by referring to you by your wrong name. So any questions?
Okay, any questions from the board? No? Randy? Okay, I do have a few questions. Is the pergola that you are seeking to add, does it cover that entire deck? And we don't have dimensions of that.
No, there is a section that's, let's see, probably as long as this table, it is uncovered on the left-hand side, but it would go to the rest of the house. The pergola is situated in such a way that it cannot be seen from 11 Henlopen.
Okay.
And it cannot be seen, actually, because of trees, from 15 Henlopen. I think it's 15. Maybe it's 17. Can't remember. The reason we're 11 and a half is because whoever built our house did not want to have 13 in the address. Or, I know, isn't that crazy?
I wondered how you got that address.
Yeah. And so, yeah, so it's always been 11 and a half. And I mean, I can tell you Amazon goes nuts because it's hard to put the half in. In any case.
Okay. They were all my questions at this point.
I just,
Dan?
could I mean, ask, so the pergola is only going to be on a portion of the deck?
Correct.
So, like half of it, or?
Don't we have the dimensions?
Well, I'm
Not
not
any-
very good at spatial aptitude. It's not my
Okay,
big thing.
but for the record, I wanted the actual
Okay.
dimensions
All right.
to be expressed.
Yeah, I did not see the pergola dimensions on the application. I did
I
see
think
the
that's
deck.
something we need to know.
There is in your packets, there is a part of the packet that directly relates to this discussion.
Okay.
And that should have the dimensions of the pergola and also a picture of the pergola.
Okay.
Yeah, the square footage is 184 square feet is what I've calculated. And if you do look in the applicant's submitted documentation, there is a page that shows roughly the exterior dimensions. Of course, there's always some overhang and some embellishment with a pergola, but it's got roughly as 276 wide inches and 132 inches deep.
Okay, thank you.
Actually, let me scratch that. It's actually 96 inches deep and not the 132.
76.
Yeah, 96 by 276 inches.
Convert that to feet.
Okay.
So it's like 23 feet by, what's 96, 12 goes 8 feet or 8.5 feet?
It's roughly that.
At this time, I'm going to ask if someone would like to make a motion. Are we okay at this?
So we can begin that way, but we can also, and I think it's useful for us to consider deliberating by raising issues that either concern us or expressing that we can that we can support the motion for particular reasons or support the application for a particular reason, or that we're concerned about certain aspects of the case and invite additional conversation before we before we get a motion, so we can have a more full deliberation.
Anyone want to start?
I'll start off, I guess, a little bit. I mean, it certainly seems that the use would be, you know, consistent with the zoning and that the character of the area is not going to change because of this. I also would imagine that if we were able to grant relief, that it doesn't really affect the neighbors one way or another. Where I have a problem, and I think it would be very nice to see, is establishing an exceptional practical difficulty if you were not to get it. And this all has to do with the rules of the city. And I was hoping that by maybe making it 6.5 feet tall only, that we could get around it. But as Matt has rightfully pointed out, that then it is considered uninhabitable, and so we can't do that and get around it that way. It does seem to me that there might be some other alternatives also. I think that you're trying to make this more usable for your personal use and provide more shade. And the idea of having a retractable awning, for instance, would be within the rules that we have. You know, I can't really comment about the rules. I mean, they are what they are. But either that or, you know, umbrellas out there. But I guess I just don't see, unless you can establish something else, because of our rules, how we have an exceptional practical difficulty here with these other alternatives, as nice as I think the pergola would be.
Would you like to respond to that? Or-
Well, I mean, we were not looking for complete shade. We were looking for being in the sun in a way in which it would be both comfortable and still allow us to have our vitamin D, if you will.
Dan or Walt, anything?
And I tend to agree with Randy in that, first of all, I just, when I got this case, I was like,
What?
you're kidding me, you know? I see pergolas everywhere, and I know these houses exceeded, you know, that the pergola, they were built to the extreme. So, you know, I was really surprised, frankly. I didn't know that we couldn't do it in this city. But that may be explaining why the person on the corner from me has an awning over her deck, a retractable awning, and not a deck, or not a pergola. So that's my situation. I am a person who likes to see consistent enforcement of the code or change the code. That's important to me.
I mean, I think one of the biggest problems for us is that the code has changed many times since we've been here. And it's really hard to keep up with that. And the plans for our renovation for our retirement happened last summer. And of course, with the lack of ability to get materials and people to work with you, it extended into beyond January. If we had done this last fall, we would be in complete compliance.
No,
And
you
that's
wouldn't have been. According to Matt, this has been always the case.
No, well, according to them, they defined it a pergola as an actual roof when they did the definition in October, in which case there have been plenty of people who have been putting up pergolas without having to be told by the Board of Adjusters that it's
I think,
not
and Matt can
correct.
clarify, I think the key word is covered.
Yeah.
Right, and, you know, it's, a pergola is a cover, so.
Yeah,
Yeah,
sort of.
And did that change? That didn't change in
that
October.
didn't
You said
change.
that's always been there.
that's always been there.
If you put a cover over top of a porch, it would count as coverage.
Okay.
So the
So it was-
October was just to clarify.
Clarification.
It was.
Right.
It wasn't to change anything.
Right.
But it did allow a lot of people to put pergolas in because the definition wasn't defined until October.
Well, it probably has to do with consistent enforcement of the code.
Yeah, and it's, you know, it just becomes really, so we've been here long enough to have lived through multiple changes in what you can and can't do in a residential area, so. We would be disappointed if you were to deny us, but we would, of course, live with it.
Thank you. Mr.
No,
Meltzer?
you have to be sworn in.
Sworn in, yeah.
Name and address.
Monty Meltzer, 11 1/2 Henlopen Avenue, Rehoboth Beach.
Mr.
Delaware.
Meltzer, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Please proceed.
Just a point of order.
Yes, sir.
So if you sat out on our pergola as we proposed to build it, and it was raining, you would get very wet, because the roof is actually not a roof. It's, the rafters are, 2 feet apart, which is nice for sun, but terrible for rain. That was my point of order.
That's more argument than a port of order, but it's a
point of
point.
clarity.
Yeah, right. Understood,
But you could sit outside.
understood.
Okay. Should we close out?
So anything additional from the two of you in support of your application before we close the record? And then we want to confirm a couple things. For one, I could ask you this. Are you aware of the letter that we referenced earlier in the proceedings in opposition to your application from your neighbor at 11 Henlopen?
Well, if you're talking about consistency of code, we can talk about our neighbor.
Okay, well, actually, yeah. So we don't want to have that conversation
Okay.
necessarily. But,
You're aware.
Yeah. Well,
so I do,
the pergola, independent of anything, would never be seen by the renters that are there. That's a rental property.
Okay.
Solely.
but I believe your testimony was because of the placement of the proposed pergola and maybe some tree buffering or something, that it would not be
Neither.
visible,
Neither would be visible.
wouldn't be visible
From
to
either side.
either of your neighbors.
That's correct.
All right, thank you.
And we were not aware of the letter in opposition. And we also didn't get the report that,
Mr. Janis,
yes, Mr. Jones. Which we thought we were going to get, so that we would be able to provide additional argumentation if we could, but we're just here to say that we're going to, we just would like to have you consider it seriously, and then we'll move on.
thank you. So,
And also, I'd like to thank you all for all the services you do for Rehoboth. This is, and Mr. Brandt, thank you for chairing this meeting. I heard from my colleague here that this is number one. So
that's right.
don't let it be on the record that we say no. How's that?
Okay, so as I noted for the record, we do have a letter of opposition, which would come in, which would be relevant under the third consideration as to whether or not the proposal significantly impacts.
Do we need to read it in?
We
or-
don't need to read it in,
Okay.
I don't think. Everyone's seen it? Yes? Yes? Yep. Okay.
And should we give them the copy of it?
It was posted online.
Okay,
and
that's right,
could-
it is, that's right, it
As
is
well as
posted.
the report that Mr. Janis prepared is also online, as well as a number of other exhibits to your application.
Okay.
All right?
Okay, any further comments?
Just also for the record, there's no one in the audience who wishes to speak to this,
They said
and,
no.
right? Okay.
Okay, we'll close out the public commentary, and at this point, ask if one of the board members would like to make a motion.
Well, I'll go ahead and make the motion, and I do it with regret, because I don't see a way that I can do it otherwise, because I don't see the exceptional practical difficulty, which is the rules under which we are governed. So I do make a motion that we actually deny this because of the lack of the exceptional practical difficulty.
Can I ask
Yes.
for a
No, no, no,
definition of
the-
exceptional?
No, I'm sorry.
Someone has to second first.
No, I'm sorry. Yeah, we're going to look for a second, but the public testimony, that's been closed.
I'll second it.
Is there a second? Okay. Okay, now we vote. So Randy, you made the motion. We will ask you to,
I vote that we should indeed deny,
for the reasons you
for the
stated.
reason that I stated, yes.
Okay, thank you. Walt?
I vote, Mr. Chair, that we deny for the same reasons. It's the three, as far as the nature of the zoning where the property lies, character, immediate use, and vicinity. I don't see where it would impact, where the removal of the restriction on the applicant's property would seriously affect neighboring properties and uses. But it's the exceptional practical difficulty, and you know, there are alternatives to provide shade and things, but that's my basis for my decision.
Thank you. Jan?
I also vote no.
For what reasons?
Because I do not see the exceptional practical difficulties. I could add how I feel about consistent enforcement, but I won't do that. I think you know how I feel, but I was, you know, as said before, as surprised as the applicants about this, but it doesn't meet the code. It doesn't meet the strict enforcement. Thank you.
Thank you, Jan. And, you know, for my vote, I am going to vote to deny as well. Number 4 in the quick check. I do not see the exceptional practical difficulty, the evidence, bicycles, you know, going by. It's nature of a beach town. I just don't see a need. And as Randy and Walt mentioned, there are alternatives that you could implement that would meet city code. So I think the motion carries to deny the application. Thank you.
I would ask,
Thank you for attending.
I would just ask Matt, you know, that I think this is an issue that needs to be raised with the commissioners about a pergola because they're.
So the issues were raised with the commissioners. That's why we did the work in further clarification and then definitions.
And they were absolutely 100% behind, including in pergolas,
Absolutely.
huh? Okay.
And I was indeed going to suggest that you go to the commissioners, because, you know, I see no reason why pergolas couldn't be, but.
I'm with you.
but
I don't
They
either.
are, you know, unfortunately.
So,
Put up an awning?
Yeah, a retractable awning, I believe, yeah.
Yes, a retractable awning or a solar shade would be great for you guys, I
As
think.
dense as you want or as light as you want, right?
it can't be wood, though. It has to be cloth.
It can't be a permanent, that's right.
Can't be permanent, right?
It can't be plastic.
So if we went to the commissioners and if they readdressed this, are we allowed to come back to you?
You
You would
wouldn't
just
have
go right,
to.
you would just go right to building inspector.
Right to you?
Yeah.
Right, but let me assure you, they're probably not going to address it
no,
in
I
our
know.
lifetime.
I'm just asking.
Because none of us, none of us are, we're all pretty old. At least in, well, not Fred, but the rest of us.
I don't know.
Thank you. Let's move on to Ann. We have the other business. Do we-
Is it okay if we?
You are done.
Yep,
Thank
you're
you so
excused.
much.
Yep.
Thank you.
So item 8 is discuss and possibly vote to require the submission of photographs in support of variance applications. Is that right? So I had been asked to look into this, and Ms. Conacy had sent me some standards that are applicable before the Planning Commission, and a number of you on different occasions have felt like in evaluating applications, you would benefit from seeing color photographs. So looking at it, it seemed to me that the best place to insert some reference to photographs would be in the application. So I kind of have a question, I think, for Mr. Mandalis. I don't know if we are, I don't think the Board of Adjustment necessarily establishes what the applications look like. Number one. I think there's a legal question here too, which probably relates to a difference between the Planning Commission and the Board of Adjustment that has come to light in other contexts recently involving clients of yours in other jurisdictions. So first question is, if this board would like to see, and I think it has expressed, would like to see applicants bring photographs to their applications, would we need to pass a motion, or could we simply ask that the administration include something in the application packet that either requires, which is going to raise the second question, or urges applicants to submit color photographs in a certain number and from certain perspectives of the property. I would like for us, if we can do it, to just simply ask that the application be revised as opposed to passing a motion. Because what we do have control over probably is our rules, but it's not clear to me that the application itself, and I've got a copy of it here, is something that we generate here as a board.
Yeah, so my response to that, I think, would be that the city code 270-76 does provide authority for the board to set its own rules and regulations, and you have rules. So it would be my perspective that since you're the board that needs to be persuaded, if you think persuasive information or evidence is color photographs, I think you could strongly encourage or perhaps require photographs. And I don't think it would need any sort of oversight by the city commissioners. I think you could add it to your application wherever is appropriate, I think, is the way I would see it.
Clarification, the application is the building inspectors, not the boards, right? So we are encouraging the change?
And I would think we would strongly encourage rather than require. I like that language better, because in some it may not be even necessary, but I think there have been a few that we might have been persuaded differently if we had seen them, frankly.
That makes it easier.
And it does make it easier.
So that comment relates to this question about the difference between the Planning Commission and the Board of Adjustment, which the Boards of Adjustment of municipalities are creatures of state law. And as we explored in the context, of that other application recently in a different jurisdiction, the municipality may not pass rules, regulations, or behave in such a manner as to abrogate an applicant's right to seek a variance. In which case, if you were confronted with someone who said they were unwilling to provide photographs, I'm not sure that we may be able to succeed if we were to take that position, but it may not be necessary if we just advise them that this board very much wants to see photographs and urge them to make them part of their application. I think that's probably the wisest way to go.
I think that's the right analysis, exactly. If somebody said, I absolutely want you to decide my application and I'm not providing photographs, I think you can say, you had the burden of proof. Photographs can be very persuasive to us, but if you don't want to provide them, we will give you an up or down.
That's perfect.
Yeah, I think so. The guy, that had the leaky roof, he had a lot of photographs, and and it really makes a difference to be able to see, your wood rotting away in front of it.
Right. So this group had been circulated an amendment to the application which says, the application for a variance, I'll just go ahead and read it in case you don't remember it. It has been, it was sent around some time ago. The application for variance or appeal must be accompanied by color photographs, at least 3 by 5 in size, 6 color copies of each photograph of the following. 1, the subject area, including existing structures, if any, where the variance from area restrictions is sought or from which the appeal is taken. 2, a view of the subject parcel from across the street that also depicts the immediately adjoining parcels or relevant portions thereof. And I think that's it. I think that's what's proposed to be included in the application. Now, that was worded as a must. I think we agree that it needs to be worded as strongly encouraged or urged. So can we get a motion to that effect?
I move that we strongly encourage applicants to provide photographs as stated by Mr. Townsend with their application.
I'll second that.
All in favor? Aye.
Okay, so that's
you.
done. I'll share that information or share that language with you, Matt or Glenn, and hopefully it can get incorporated into the application for future applications.
And Anything else?
One real quick thing. I think that, I think you'll be asked to take a look at your rules at the next meeting. If you want to review them. In anticipation of that meeting, I'm going to circulate something which might contain a number of different, I would call them minor modifications to the rules. So if you've got anything in mind in that context, start thinking about that. If you want to communicate with me in anticipation of the next meeting on that subject, please do so. But you will get something, though, coming from Ann or myself, which asks you to look at the rules. I think we may be considering something on the agenda for the next meeting.
Okay. Inclusive in rules, my engineering background, do we show red lines?
Yes.
I mean, I love the way you did
Yeah, no,
did this.
we will.
Okay. Proposed red lines. That makes it a lot easier. You don't have to memorize the whole thing.
Right, right, yep.
Okay.
Excellent.
And we have, I mean, I've got a big file like this, that, so we have those rules in our Board of Adjustment files, or are they online somewhere?
I mean, I'm going to be sending them out.
Okay, all right.
I'm only raising this because you may have some of your own thoughts
Okay.
that you want to bring independently of that discussion. And if you do, make a note of them, because I believe we're going to be discussing them at our next meeting.
And do we have, I mean, if we don't have a case, will we still have a meeting?
That remains to be seen.
Okay.
Do we have
Do we have any cases coming?
We've got
We
one.
do,
Okay.
okay.
So we'll be here a month
That takes care
from
of
now.
that.
Okay. All right. I think with that, the meeting is adjourned. Thank you.
Do we need to make a motion for?
Yep.
Oh, yeah. Oh, yeah. Here we go. Make a motion
Mr.
to
Chair, I'll
adjourn.
be happy to do that. I'll make a motion for adjournment.
Second.
All in favor? Aye. Thank you. Thank you for